Welcome to today's video. I'm Richard Chapo. I'm an internet lawyer in San Diego, California, and today we are talking about the CCPA, Consumers' Right to Access. So the CCPA is the California Consumer Privacy Act. It is a new privacy law in California. It goes into effect January 1st, 2020. The CCPA is a bit of a revolutionary privacy law for the U.S. because it goes well above and beyond what we've normally seen in the consumer markets. And we're talking about situations where businesses are collecting data from individuals. And the CCPA is different in that it grants quite a few new consumer rights. And so as a business, if you own a website or an app or whatever it may be, and you're collecting personal information, well, you need to understand what these rights are and how you must respond to them. So let's dig into the consumer's right to access, probably the first right that we have under the CCPA. And I'm just going to read the clause to you so you know exactly what it's requiring. A consumer shall have the right to request that a business that collects a consumer's personal information disclose to that consumer the categories and specific pieces of personal information the business has collected. So that's pretty concise and on point. So you're going to need to identify your personal information practices, what data you're collecting. You're going to need to divide that into categories. And in your privacy statement, you're going to have to list those categories. You're also going to have to identify where that specific information is and figure out how to collect it and provide it to consumers upon request. Yes, you're going to have to affirmatively provide it to them. Consumers can make the request for their specific personal information, and you have to give them all of it. So that's a change. The days of putting up a simple privacy policy and not looking at it for 10 years are over. The privacy, the relationship with your visitors on the privacy front is now interactive. They can make requests. You must respond with physical documentation in some instances. So make sure you understand how this process is going to work. Now, the caveat to this is when we say personal information, remember the definition of the CCPA is very broad. It goes beyond the person's name, email address, phone number, and physical address. It includes things like IP address, any other data that you might have, that you're using regarding them. So it might even include things like geolocation data, profiles that you've created, anything of that sort. So you need to understand exactly what you're doing there. Now, when do you have to give notice of these categories and the right to request specific information? Well, before or when collecting the personal information. And there's some controversy over what this actually means. Right now, most attorneys seem to have settled upon the idea that as long as you have it in your personal or your privacy policy or a separate California notice of privacy rights statement, you're probably going to be fine. But this is an area you want to keep an eye on. Now, can this system be abused? And the answer is yes. You're probably already thinking about it. How do I know when somebody submits a request for their personal information that it's actually that person? How do I know it's not a hacker or maybe an ex who's got an axe to grind? And the answer is you must verify that it is the actual consumer. And this is known as the verified consumer request process. And how do you verify that? Well, the CCPA doesn't set out any specific methodology. Instead, the California legislature has instructed the Attorney General of California to issue regulations for the CCPA that should include some methodology. Now, the problem is we don't have those regulations yet. The California AG is expected to issue the first draft in October, so hopefully at that point we'll at least have an idea. But so far, we don't have any indications as to how to do this. If you're trying to prepare now and trying to get into compliance now, talk to your attorney about setting up something that can be defended as a reasonable approach. And at least you have something in place there. With the AG not actually having issued regulations on this yet, we don't really expect this to be an area where there's going to be a lot of enforcement actions initially, because if you don't know the rules, well, how are you going to comply with them? So what do you have to actually deliver when a consumer makes a request for their specific personal information? And you have to deliver all that personal information. So whatever versions of it you have to produce. Again, it's not just their name and email address, phone number, physical address, and maybe payment resources if they purchase something from you. It needs to be everything. You can deliver it by physical mail, the old traditional snail mail, or electronically. If you do it electronically, it's supposed to be in a portable form and, quote unquote, where technically feasible, in a format that can be used on other sites and services. Nobody really knows what that means. That makes me a little nervous. So physical mail might be the best solution. Can you charge the consumer for the time and effort to collect and deliver this data? And the answer is no. It must be free of charge. How often can the consumer make the request? No more than 2 times in 12 months. And the reason for that is obviously we want to avoid abusive acts by the consumers. So 2 times in 12 months, free of charge. You can deliver it by mail or electronically, but make sure it's all the personal information. Now, all this doesn't probably sound too difficult, but really where the complexity comes in is you need to identify, what is personal information that you're collecting and what are the actual processes that you're going to have to respond to these various requests, because you're going to need to have procedures in place so that when that first request comes in, you're able to handle it. Who's responsible for it? What information are we collecting? How are we going to produce copies of this information? And you need to set all of that up beforehand so you can comply with the CCPA. Are there any penalties associated with failing to comply with this? Yes. You could be hit with an enforcement action by the California Attorney General, and they can issue fines penalties for $2,500 to up to $7,500 per violation. So you probably don't want to get this one wrong, because if you have one violation, you're probably going to have 20 or 30 or 40 or 50, and that number climbs pretty quickly. So that is it for the CCPA, Consumers' Right to Access. If you have any questions or comments, feel free to contact me at SoCalInternetLawyer.com, or you can post them down below in the comments section. Please keep in mind that is a public forum, and you should not post anything that's confidential or sensitive. If you enjoyed the video, consider giving me a thumbs up. If not, I feel shame. Give it a thumbs down. And you may want to go ahead and subscribe to this channel, as we'll be posting quite a few videos on the CCPA. And in fact, if you go to our page on YouTube, you'll see a playlist that is devoted entirely to the CCPA. So hopefully you can find answers to any questions you might have on that playlist. So thank you for watching. Have yourself a good one.